Crimes of violence and attack. This is lecture 11. (240) is assault. It's an unlawful attempt coupled with the present ability to commit a violent injury upon another. So if I decide that I'm going to beat somebody up and I go chase them into a room and I'm chasing them around the room, I can't catch them, I almost catch them, and they're able to get away from me, then that would be the example of an assault. It's an attempted battery. Battery is where I make the contact. Assault is where I'm trying to make the contact. The present ability is there because I got ever so close to catching that person. And violent injury would have been, the definition of violent injury is pretty simple. It just means unlawful touching of the person. The things that are not classified as assaults include sporting events that are not unlawful, self-defense, medical operations, obviously somebody's given permission to cut inside of you, or make an incision, or force during lawful arrest by peace officers. Now, the attempt must be an uncompleted action. There must be an intent to commit harm against the person. Present ability. They must have been able to complete the act. Not important that some condition prevented the assailant from completing the assault. So an example could be that if I was out on a football field and a person is 100 yards away from me, and I'm taking a softball and I'm trying to hit them with it purposely and I'm throwing it at them, my maximum throw is probably going to be 30 to 40 yards. Therefore, I don't have the present ability to make it to 100 yards and actually commit the violent injury. Now let's change it up. I now get a bucket of golf balls and I get my 8-iron, which is good for about 120 to 160 yards, and I start lobbing the ball at them. Now I would have the present ability to complete that. So if someone's trying to throw something at you and it doesn't reach you consistently, there's no assault. But if somebody is close enough to touch you with whatever it is they're throwing at you and someone else swats it down, then they prevented the assault from being completed. So therefore you still have an assault. Violent injury is the unlawful application of physical force upon the person of another. It could be grabbing your clothing. It could be throwing water in your face. It could be spitting at you. Any of those things are considered violent injuries. You don't have to actually have an injury per se. Okay, a quick quiz. Number 1, Jojo points an unloaded revolver at Sam. Is this an assault? Number 2, Jojo points a semi-automatic pistol at Sam, which has a full clip but nothing in the chamber. And we'll talk about that under People versus Bennett. Number 3, Jojo throws a baseball at Sam's head, but Sally swats it down. Number 4, Jojo throws a baseball at Sam, but doesn't quite make it to Sam's location. We just spoke about that. Number 5, Jojo swings his fist at Sam, but Sam moves out of the way. And number 6, Jojo pours water over Sam's head, but the glass is empty. So what do you think? The answer's number 1. A revolver takes a long time to load. You have to open it up and physically put the bullets into the cylinder. So the answer is no, the revolver's empty, it takes too long, and there's no present ability. Number 2, an auto pistol, some automatic pistol like a 45 or 9mm has a magazine that holds the bullets. If it's in there but there's nothing in the chamber, all a person has to do is pull the slide back. Now, in the People versus Bennett, the court stated that that was enough. So having the difference is having an unloaded revolver pointed at somebody, having an auto pistol, which has a full magazine pointed at somebody but nothing in the chamber, it changes the situation there. So with the auto pistol, yes. Assault. Revolver, no. Number 3, The answer is yes. And if I recall, number 3 was where the person throws something at JoJo and somebody knocks it down. Number 2 is where the person is throwing something consistently and it is not reaching them. That's number 4, excuse me. Number 4, no, there's no present ability because it's not reaching them. Number 5, the answer is yes. We'll get these numbers straight eventually. And on number 6, no, there's no present ability because there's no water in the glass. If there's no water in the glass, you can't throw water on someone. I know that's kind of a trick question, but hopefully you understand where I'm coming from with this. 242 PC is battery. So now you had the assault, which is an attempt battery. Now you've completed the battery. Battery defined as the willful, unlawful use of force upon the person of another. And so it's a completed assault. Pushing someone, grabbing someone's shirt, kicking someone, tripping someone, throwing books at someone, throwing coffee in their face. And again, depending on the level of injury, we can deal with whether these things are more serious than just a simple misdemeanor battery. PC 241 basically defines certain employment as special classes that would give the defendant a harsher punishment. Examples include a peace officer, public safety personnel, like a traffic cop or a meter maid, a jailer, emergency medical technician or paramedic, a doctor or a nurse, a teacher, a school administrator, or a security officer, peace officer or school staff, bus, cab, or streetcar driver, armed forces member if they're on active duty. And these are all misdemeanors, but with 1 year in county jail, except the jailer or any peace officer. It's a felony to commit a battery on them. 243 felony battery, and I give you subsection C1. It's peace officer. It's a wobbler up to 3 years if there's injury. And if there's great bodily injury, it's up to 4 years. Definition of injury. Basic injury is where medical treatment is required. Great bodily injury includes loss of consciousness, concussion, bone fracture, protracted loss or impairment of any bodily member or organ, wound requiring extensive suturing, or serious disfigurement. PC 243.4, sexual battery. This is where a person touches any intimate part of another person's body without permission. The difference between it being a misdemeanor or a wobbler is if the victim is restrained. Intimate body parts include sexual organs, buttocks, and the breast of the female, and any of these things can be done through clothing. Cases that usually occur, I can remember that in Berkeley there were fraternities that had competitions to touch female breasts, and what they would do is go outside of a pub or a restaurant, and as a female walked out they would bump into them and touch them inappropriately. And in these cases, after a while, they would call the beat officer, and the beat officer would do some surveillance and make arrests. If two frat boys go to do this and one grabs the female and holds her while the other one touches her, that would be the felony or the wobbler. 244, assault with caustic chemical. When I say caustic chemical, I'm talking about anything that's caustic that could injure the flesh or disfigure the body. It requires willful, maliciously places or throws a caustic chemical of any kind with intent to injure the flesh or disfigure the body. It's a felony up to 3 years. Typical case could be oven cleaner or any sort of acid or cleaner that has acid in it. To be distinguished between that and the use of mace or pepper spray. Mace or pepper spray are not considered caustic chemicals. and they can be used in self-defense. If they're not used in self-defense, then they could be a felony or wobbler for use of pepper spray or mace. 417, brandishing weapons. Except in self-defense, displaying a weapon in a rude or threatening manner. It's a misdemeanor except in the presence of a peace officer. Includes sections for weapons and guns separately. What I want you to do is to review 417 and look up the following sections that are listed in this lecture, including 417A, brandishing a weapon. Know that that could be a bat, a stick, a brick, where 417B is brandishing a firearm, and there's a definition of what a firearm is. 417C is the same thing, but in the presence of a peace officer, and it makes it a felony. 417.4 is use of a firearm replica, and this is a misdemeanor. 417.3 is where the weapon is pointed at a motor vehicle, and that's a felony. 417.25 is pointing a laser. If you've seen these little laser lights that people have, if they point it at your face, in your eyes, on your clothing, they mark your clothing with the laser so that it's significant for you to feel that you might be in fear of your life, that someone is about to shoot you. That's a misdemeanor. And 12024 is weapon possession with intent to assault. Somebody gets a bat or gets a gun or gets a knife with the intent to assault. That's a misdemeanor. Now, in the case of brandishing, the person does not have to point the gun at you. They could open their coat, have the gun in their waistband, and say the words something like, "It's time for you to go." And that would be considered brandishing. You're not pointing at it. I can remember as a young beat cop, it was very common for officers to have their baton out in their hand and them touching, basically tapping it against their palm and saying it's time for you to leave, to somebody who would be sitting in the park after hours or drunk on a bench, passed out. You want them to move along, and they would typically have the baton out. Now I know that I could have been charged, or officers that do that sort of stuff might be charged with 417 A, brandishing a weapon in a rude and threatening manner. Something good for you to know in the future. 245 PC is assault with a deadly weapon. It's a very common occurrence. Every person who commits an assault upon the person of another with a deadly weapon or a deadly instrument, or by any means likely to produce great bodily injury. Now, common deadly weapons could be an iron bar or a pipe, a glass ashtray, a branch from a tree, a nail file, a pencil, a pen, glasses, or a bottle, or any type of straight razor or a cutting instrument. Circumstantial evidence in proving 245. When you go to the scene, you might find the suspect has removed and hid a weapon on you, and you can't find it anymore. But you can establish the corpus delicti for the crime from witness testimony or examination of the wound. If someone falls down and injures themselves, it's going to be a very jagged kind of a puzzle sort of a configuration of the flesh. When you look at the skin, it's going to be very very coarse and very jagged. If someone uses a straight razor or a cutting instrument, a bladed instrument, you're going to see a very precise straight wound. Now, I talk about discussing the difference between 417 and 245. If someone comes into a room, or they're standing at a doorway, and they have, again, I'm going to use the baseball bat. They're standing at the doorway, they've got a baseball bat. And they show you the baseball bat, and they tell you, if you don't leave, I'm going to hurt you. Well, that's brandishing, right? And it's 417A, brandishing of the weapon. But if they come in and they start to chase the person around the room, or they swing at them and miss, and the person gets away, that's assault with a deadly weapon. Or if they swing it and they hit him, it's assault with a deadly weapon. And additionally, maybe other felony assaults that would be able to be charged. If a person shoots a warning shot in the air, um, would it be 417? It might be, except it says in self-defense. Now, if it's in self-defense, they're trying to protect themselves, and I would say in the air is not a good place to shoot the gun. You would probably be better off shooting it down into the ground, into soft dirt or grass, because you know where the bullet is going, and you may be able to justify to a judge that it was to prevent the use of deadly force, and to deter the person from further attack. And you might be able to convince a judge of that. If a person is trained and found guilty of assault with a deadly weapon with hands, typically in Alameda and Contra Costa counties, it's very common for people who have martial arts training who are brick breakers. You know, they're breaking boards and bricks. They're using their hands in a fight. They're going to get charged with assault with a deadly weapon because of the additional training. The other thing is that people who kick people who are down, because of the strength of our legs, is if they have any sort of special shoes like these metal tip boots, they are going to get charged with assault with a deadly weapon, 245. Penal Code sections that I want you to research and review include PC 347, administering food or drink to a person, that's a felony. PC 220, assault with intent to commit rape, sodomy, oral copulation, or mayhem, that's a felony. PC 222, administering stupefying drugs or intoxicating agent which impairs the power of self-control. PC 203 and 205, mayhem and aggravated mayhem. And H&S Health and Safety Code 120291, which is HIV exposure with intent to infect. So you need to go to the California Penal Code, which you know how to get to online, and look up, and you're responsible for being knowledgeable about those Penal Code sections. PC 692 is lawful resistance of a public offense made by the party about to be injured or by other parties. And PC 694 is defense of others sufficient to prevent offense, and it's a reasonable person rule. I'm giving you both these penal code sections. You should look them up and read them. And what they talk about is that you can defend yourself, and you can defend others who are about to become victims of crimes or about to be injured. You can use reasonable means to defend yourself, up into the use of deadly force. Assault justification. You can use force to accomplish an arrest. Children can be spanked within legal limits. You know, if you have a child that is going to run in the street and you want to associate a spanking with running in the street because they don't understand getting hit by a car. As a cop, I went with the 3 SWAT rule: 1, 2, 3, no marks. We're going to be talking about domestic violence a little bit, but there is in the penal code, it says that you're responsible for your children. So as long as you're not injuring them, but you're correcting their action, spanking might be appropriate. But that's up to the individual. I'm not advocating that you need to spank your children. Not at all. Also, assault justification can be made on an accidental or mistake that occurs and someone is accidentally hit or pushed or whatever, and that would not be assault either because there's no criminal intent. We're going to talk about domestic violence, a very hot topic right now. We're trying to train officers to be a little bit more assertive and know what the penal code sections are they can use to try to prevent violence in the household. PC 273.5 is infliction of injury on a cohabitant. Now, definition of cohabitant could be a spouse, a former spouse, or like we say, baby's daddy or baby's mama, or his or her child. A traumatic condition is a wound or external injury, whether of a minor or serious nature, meaning that you have a mark of some sorts that you can see that there's a traumatic injury. How do we establish cohabitation? You know, when you're at a case like this, you want to go look around. Do you see a checkbook? Do you see a joint checking account together? Are cars registered together? Do both people have keys to the house? Are there both parties' clothing there at the house? You need to establish this so that you can use this section if it's appropriate. Domestic violence codes. Again, I want you to look up the following codes: PC 273.6, protective order violation. If you go into a domestic violence situation and you uh, are going to make an arrest, and you're going to tell or you're going to tell a person don't come back, and you go get a temporary restraining order, which does not take very long. It's a one-page form, a call to a judge. They authorize you to sign their name on it. You serve it right there. The person can't come back around for the next 5 days until you can get the victim to regroup and get some resources and help. As a result, the suspect comes back. It's a violation of a misdemeanor, 273.6. You can make an arrest. And by the way, this is one of the few sections of a misdemeanor that you can arrest for a misdemeanor out of your presence. The next section I need you to look at is PC 591.5, destruction of a wireless device. This would be where the person, there's also a section that deals with destruction of phone line. If the victim is trying to call 911 and the suspect simply puts their or rips the phone out of the wall or takes it from them and smashes it, you're looking at a misdemeanor. If they cause damage to the phone line, or they prevent them from making the call, if they prevent them from making the call, that can be considered also a violation. TC 273A is child endangerment. That's a wobbler. 273D, cruel and unusual punishment of a child with a traumatic condition. This is also a wobbler. This is where the person's using a belt or a board or a something other than the hand to spank the child, and they're putting marks on them.